Taxation is theft.
Please, at least leave us alone in our living room.
My job is to find the truth.
Double the taxes. I'm a human being. God damn it. My life has value. Triple the taxes.
This is an IRS agent's dream.
If you think that the Capitol will ever treat us fairly, you are lying to yourself.
Beautiful, lovely taxes.
Sorry, but I don't do taxes.
Did you see the memo about this?
The government is a greedy piglet.
Just leave us alone.
Do you know what Ralph just said?
The roads.
You boys like Mexico?
I'm as bad as hell, and I'm not gonna take this anymore.
Welcome back. Taxation is theft. And I have with me today Eddie Craig, who's the co-host of Rule of Law Radio. And he's got a couple websites. They're up on the screen with a lot of really great information. You might know Eddie from, there was a video he put up online, and it's had, I think, over 1 million views now, where he gets into whether or not you need a driver's license to drive, or whether it's for, or the video explains that pretty much you don't. It's for commercial purposes only, and it's a very detailed, tricky system that they've built to convince us that we need to have licenses to exercise our free right to travel. So this was a great video that I saw years ago, and I think that was that put up by InfoWars?
Yes.
So,
and they've actually on YouTube, they've reset the hit count on it many, many times. It's been in the tens of millions over the 11 years it's been up there.
I didn't know they did stuff like that. It doesn't surprise me at all, but
yeah, and that doesn't even include the hits on the reshares and everything else that I've seen out there. There's a lot of people that's seen it.
Wow. So that's really awesome, because there's before I even moved to Texas, back in California, I started reading about this, and it was really difficult to understand. So, and one of the reasons I reached out to you was because, like so many other things, when, these things are really complicated, but you put this video together, and if you just sit and listen to it, you actually did a really great job of just straight line going from this is how they get you. So I really appreciated that, and I thought it was a great explanation, because it's such a convoluted system. Like when you talk to people about this, when I talk to people about this, it's the indoctrination. It's everybody needs a license to drive. It's it's a privilege, not a right. All these things come up, and it's not like you can just point to one line in a law book that says, no, look, it says right here, because that isn't there. It's this big thing of smoke and mirrors to confuse us all. So yes, I want to thank you for. Go ahead.
I'm sorry, go ahead. I was going to say that's one of those things that it's by design.
Right.
But the key to it is understanding what the limitations of what they design is actually constrained to. And that's where most people fail in getting the proper education on both their state constitution and how their state legislature is allowed to create law, and how their power is far more limited than they would lead you to believe that it is.
Right.
And that's the entire reason the government took over the education system, was to stop the education of the American people on rights, liberties, their state constitution, how their legislative system works, why it is supposed to be representative government, not dictative government like it's become. And once you understand those concepts, then understanding what's actually being done becomes a whole lot easier. And that's what I tried to do in that video, is to show you that there are boundaries within which they must operate. Once you understand those boundaries, this is no longer so hard to contemplate and understand how it must work in order to be valid. Right.
And so much of it is just words that they use. They take words and they redefine them to mean things that, there's one word that's in the law, and we believe that it means one thing, and it means something completely different in the world of the courts and the legal system and everything else.
Right. And that's another trick that the courts and the government in general have developed, is that they insist that they must use the common meaning of terms and phrases when they're reading and applying the law. What they don't bother to explain is that there's an exception to that rule in every case, and that is when the legislature specifically creates a definition for that term or phrase within the law. Once the legislature does that, the court is no longer free to apply the common English meaning to that term if it just so happens to look and sound exactly like the same term in common English, like person, for example, or drive. Those are terms that are defined either by inference within the law or directly within the law. And by inference, as an example, being that they don't define the term drive, they define the term driver. And by inference, you must then derive the definition of drive from driver. But between those two, there is a legislative subject matter context in which it is contained. And this is where the courts have hidden the truth from the public in such a way as to make them believe one thing when reality is something else. That legislative context is what the courts always ignore and always fail to mention in the course of their opinion. They treat the individual things within the law as if they are their own individual subject. And
Right.
that violates the state constitution's mandate of how law is created. In Texas and in every other state that I know of, every state constitution and their legislative branch, they're limited to a single subject. It used to be a single object within a legislative bill. Now they've made it where they can write about a bunch of different objects as long as those objects all pertain to the same subject. This is how they got away from being able to pass one little piece of legislation at a time to being able to pass volumes of legislation in one pass.
Like Obamacare.
Exactly. But it's also why the law has been broken up into more or less individual codes or individual titles within those codes. Those titles or individual codes constitute that volume of legislation limited to that one single subject. And that was the groundwork for the video that you're referring to. Everything depended upon what the legislature said the law applied to. And in Texas, it very clearly states that that law applies to transportation.
Right. So I want to say, because that's a really difficult subject for someone to wrap their head around. I know I struggled with it for a long time. If there's a law that says everybody has to do something, but when it's in the context of a bill and that bill is limited to a certain jurisdiction, that everybody doesn't mean everybody. So,
Exactly.
For example, if it's like, if it says, here's an obvious example in the U.S. is if it says everybody must register their car in Texas, well, if you don't live in Texas, then obviously you don't have to register your car. So there's still some sort of context, and you have to know kind of what that is. Another example might be, you're playing a game of Monopoly and you land on the income tax square, and it says you have to pay $100. You have to pay 100 Monopoly dollars. Your opponent is not going to force you to take out your wallet and give him 100 Federal Reserve notes cash. We have to kind of understand that these contexts kind of they limit what these words mean. So if someone uses the word everything, it still means everything within that little bubble of context that law is allowed to talk about. Is that
exactly? And let me see if I can. I'm actually making a PowerPoint presentation. I'm going to turn into another video and post when I get it done. But the way I'm setting it up is like this. You can call the legislative bill a container, a box, a fenced-in circle. You can call it a tree. It doesn't matter what you call it, but you have to understand one thing about that container or that tree. It can only have one kind of fruit growing on it. It can't have anything else if it's a tree. If it's a container, you can only put things in that container that specifically belong to the subject that container is labeled for. For instance, let's say you're relocating your house and you're packing up your boxes to move. and you have boxes labeled kitchen spices, okay? If you are not allowed, according to your own packing rules, to put anything in the box labeled kitchen spices other than kitchen spices. You can't put spatulas in there. You can't put silverware in there. You're limited to only putting kitchen spices in the box labeled kitchen spices, okay? That's the simplest way to understand the single subject matter clause of your state constitution. It creates a container, an individual thing, and anything that's being put into or that you're claiming is related to or produced by that specific subject is the only thing that you can put with it. So, in the case of the Texas Transportation Code, here in Texas, our Constitution says that they have to put the subject matter of a bill in that bill's caption so as to notify the public specifically what the purpose of that legislation is. And when they recodified the current version of the Transportation Code back in 1995 in a bill numbered SB 971, Senate Bill 971, the caption of the bill specifically stated that this is a non-substantive recodification. Non-substantive meaning that they were not making any changes of substance to the law, okay? All they were doing was reorganizing, renumbering, and rewording the law to make it clearer, is how they put it. They didn't make it clearer. They intentionally made it harder to understand. But once you know how they're limited in even doing that, it still doesn't change the subject matter. The subject matter in that non-substantive change is all laws relating to transportation. Now, there is not a single Texas law on the books that defines the singular term transportation anywhere. It does not exist. There's not even a Texas court opinion that defines the singular term transportation. That is not to say, however, that there is not other law that defines the term transportation, because there is. Here in Texas, we have two chapters out of a very important code. It's the Texas Government Code, chapters 311 and 312. Those two chapters deal with how laws are to be read and interpreted by the courts, and it deals with how laws are to be written and how terms and phrases within those laws are to be defined and understood by the legislature and every agency of government. Okay? The courts are not free to interpret a law any way they want. They are constrained by these two chapters on interpretation and legislative intent as to how they can interpret a law, period. Whether they want to claim they are or aren't is irrelevant. If they claim they aren't, then you have a court acting unconstitutionally to legislate from the bench. If they attempt to alter how the legislature writes a law and how the legislature wrote it to mean a specific thing, the court is still legislating from the bench. They are attempting to alter the legislative intent and the legislative meaning to get an outcome that the court itself desires rather than the one the legislature intended. All of that is unconstitutional on its face if that's what they're going to claim they are doing. That is, in fact, what they are doing. But knowing that and being able to prove it is what that video you mentioned is all about. Here is what they're saying. Here is how they're applying it. Here is what the law actually is. And when it's all taken within its proper context, in the lump sum it's required to be taken as, it doesn't mean what they tell you it means at all.
So I kind of wanted to start out with this, but we'll backtrack a little bit. I wanted to get kind of your history and how you came to this, because I can only imagine that you went to a government school, you were taught driving is a privilege, not a right. You got the same indoctrination. Maybe you went to law school, and how did you kind of, I guess, what was your upbringing, and how did you kind of end up where you are? And was there a turning point where you kind of realized that this was going on contrary to what you were learning?
Well, yes and no. You're right. I went through the same school system everybody else did. I guess I had the benefit, however, of a mother who made me think for myself. Basically, I would come home from school as a kid. I would get my homework done. As long as my homework was done, the rest of the day was mine to do with as I pleased. And I did everything. I was very independent. And so if someone tried to tell me I had to do this, that, or the other, my first thought was to always ask, well, why do I have to do it that way? Now, in adulthood here in America, we're taught that we have to assume and comport ourselves under certain responsibilities and requirements and all this other stuff. But when you start looking at what you're being told, and it starts to conflict with the things that you have been told in other places, and they don't gel when they're mixed together, you start to understand something here is not right. It's like catching somebody with their hand in a cash register in a convenience store, and they don't work there. And yet they're trying to convince you they're not robbing the place.
Right.
I'm just making change. Really? You put in an empty hand and you come out with a fistful of bills and you're making change. How is that making change? Something about your story doesn't mesh. Well, that's kind of the way I began to look after spending 14 years in the Air Force at the way the government was telling us this, that, or the other, and then what the truth really is versus whatever. For me, it became crystal clear when the county tax assessor back in my hometown tried to steal my mother's house and land. They assessed her with a property tax that was absolutely outrageous and claimed that they had all the authority in the world to do it based upon the tax code and the state constitution and blah, blah, blah. And so at the time I was working as a computer consultant. I was making really good money. I could afford an attorney if it had come to that, but it didn't. Instead, I made them tell me exactly what law they were basing this so-called assessment on and how it was required to be done, et cetera, et cetera. And I started tearing the tax code to pieces. And I found out that they were not following the tax code that they were claiming they were using. They weren't following it at all. Everything they had done to assess this tax against my mother's property was absolutely illegal under their own code. They had done nothing they were required to do. And then when you get a little further into the things they are required to do, you find out who they're actually required to do it to. And it turns out it's not us, has never been us. Just like every other tax on the books, it has property tax has a very limited application. And that application is to property belonging to corporate entities operating within the territorial borders of the state of Texas. It has nothing to do with the private land and property owned by individuals for their homes. Nothing to do with that at all. Right. Yet they treat it as if it does. Well, I took that information, I went down to the county tax assessor, and I put it down in front of him, and I made it very, very clear that if they proceeded in any way, shape, or form to move against my mother or her property, I would sue them until I owned everything they ever thought of possessing. Because I knew what the law was, I had brought them evidence of the law and how they were abusing it and how they were not applying it in the way that it was written. And they never sent her another tax bill. They backed off, left her alone, and never sent her another tax bill while she was alive. And so I took that and I started applying that to all the other things that I was doing at the time. At the time, I was working as a computer consultant. I was serving in the reserves in the Air Force, and I spent a lot of time dealing with government regulations. In my time in the Air Force with the various jobs I had done for them, I had learned how to read government regulations very, very well. And when it comes to reading statutes, it's not a whole lot different. Once you learn the ins and outs of it, it actually becomes pretty simple. It's just a matter of understanding how you have to break down a statute versus how you would normally break down an English sentence or paragraph to learn what its subject is, what it applies to, what it really means, and then you go from there. The difference there is that in statutory terms, they very rarely put all of the statutes on a given subject in one place. And what I mean by that is that even though we have a transportation code where all the statutes relating to transportation are located, we have various other codes that deal with things from that code. For instance, motor vehicle. When it's used in other codes, the other code will say that it has the same meaning as defined by section such and such of the transportation code. So there are lots of different codes in lots of different places where motor vehicle may be referenced. And when you start looking at how it's being used in those other codes and how it's used within the transportation code, you come to understand that the other codes cannot use it any differently than it is in the transportation code. Why? Because it specifically says it has the same meaning as it does in the transportation code. So they can't apply it to something other than what the transportation code applies it to. Any attempt to do that is an attempt to change the legislative meaning and intent of that defined object. And this is where so many people and the courts themselves tend to hide the truth in the way that they do things. They do it all by verbal sleight of hand. They use terms and phrases that we all think we know and understand, just like you mentioned in the beginning. And we assume that it's the same meaning we understand it to be. And that's not necessarily, or even the majority of the time, true.
Right. So let me ask about this one, because I've tried to do my research on this one in Texas, because there is, there was a big debate over whether or not hair braiders should need a business license. So I started looking into that, and I pulled up the Texas Constitution, and I just searched, because it's several pages, and I was like, okay, I just want a quick answer. What does it say about business licenses? And I searched, and I couldn't find much. The only thing that I found that gave them the authority to require licenses for any business was oil businesses. And I would assume that maybe they claim that authority because they claim the land and the mineral rights and everything else to that. Is that kind of true for that, or
no?
Or does that
they
come from some other...
intentionally abuse a couple of different things out of both the state and federal constitution: the Public Health and Welfare Clause and the police power. The courts are the ones who declared the existence of the police power. Police power is not a phrase that is anywhere in any constitution. The courts have ruled that it's inherent in the power to govern because the government is given certain authority to do certain things, and therefore the government must have a way to enforce its ability to do those things. But what they never ever do is they never take the powers that the courts or that the individual pieces of government are given and contrast them with the fact that we cannot use these powers in a way that violates the Bill of Rights within that same Constitution. We can't use these delegated powers in a way that those who gave them to us don't have a way to use them. See, this is the thing about limited government that they seem to not understand. And that is the power of the people to delegate certain authority. If I don't have the power to do something to you as your neighbor, or to order you to do something as your neighbor, or to stick my hand in your business as your neighbor, how can I do that then by saying that our other neighbor down the block, I'm going to say I give that power to them to do it for me? If I can't do it, how am I going to give them the power to do it?
Right.
And yet that is exactly what the government keeps trying to say that we the people have done. We have somehow given them an authority which they have deemed governmental necessity, the right of necessity, to do things that we as individual people simply cannot do to one another. And that right there is a complete and total misinterpretation of delegated powers.
So so let's look at traffic court, right? When you go into traffic court, the reason they're able to charge you and fine you is with the presumption that because you're there, you're admitting, or you're not objecting to them calling you a driver. You're basically agreeing with them. Yes, I was driving, and so then that's not what's in question. What's in question is whether or not you were exceeding the speed limit or used a blinker or whatever it may be. It's assumed that you're a driver, and in that context, they could apply these laws and enforce these fines. With all of the things that you're talking about, is there some sort of premise that they're that they're using to make all of these statements? So if they're enforcing a business license on someone, or they're taxing someone's property, or gun licenses, even I looked in the New York State Constitution, and I didn't see the word gun or firearm or weapon or anything in there once in the entire Constitution. So is there something that they're using in all of these varieties of cases where they're basically saying, oh, we're going to treat him as a person because he's not objecting to being called a person?
Yeah, that's exactly what they're doing. But this is what I was saying about you're being told one thing, but then you know for a fact it's something else. Here's the problem with the way they're doing it, and why it's easy to prove that they are not only abusing the system they claim we have, they're breaking their own rules when they do it. And it's a very in-your-face way if you know what those rules are. When you don't know what the rules of the game are, and you're letting someone else tell you what those rules are, then they can tell you anything they want and always win the game, can't they?
Right.
Okay, so let's look at how the courts are actually doing this and exactly how this works through all of this. The thing about them presuming that you're a driver, yeah, they're presuming that. But here is the problem according to their own written opinions. The United States Supreme Court has several opinions in which they have stated that in a criminal matter, which is what a traffic case is in Texas, they are treated as misdemeanor crimes, Class C misdemeanors in 99% of the cases, okay? They are not civil, they're not administrative, they are criminal. No ifs, no ands, no buts. The United States Supreme Court has said that in a criminal matter, no element of the alleged offense can be presumed. It must be asserted and it must be proven. When was the last time, when was any time that you have seen a court in Texas file a complaint that alleges the individual is being accused of engaging in transportation so as to be guilty of the act of speeding?
Well, I guess not the engaged in transportation part. It
Exactly.
Usually...
But here's the problem. That is the key element. No other element can exist if that one does not exist. Why? It
Right.
goes back to the single subject issue. In order for a speeding offense contained within the transportation code to even be applicable, to exist, to have any authority to operate at all, the individual themselves must be under the subject matter that offense relates to. If they're not, then how can you charge them with the offense?
Right.
It's just like what you were saying before. If Texas has a law for this, then how do you charge someone in Louisiana who's never even been to Texas with a violation of that law? You can't do it. They were never under the jurisdiction of that law to begin with. And that's exactly the issue with transportation. When they fail to allege the individual was engaged in transportation, they are not invoking the subject matter jurisdiction to which the offense applies. That makes every single conviction that follows illegal, unconstitutional, based upon no law whatsoever. This is what I was saying about how they're treating the individual offenses and individual things they're charging you with as subjects unto themselves that somehow exist separate and apart from the transportation issue. And that cannot happen without violating the state constitution and the legislative mandate that all of these objects down here must relate to the single subject of transportation. Hence, No subject matter, no object. It cannot be any plainer than that. You cannot take my lemon tree and make it grow cherries. Can't do it.
Right.
In fact, you take away the tree, I can't even get lemons, can I?
Right. So if somebody learns this information and they understand it, and the next time they go to traffic court,
Well,
is it as
first
simple?
thing is, don't refer to it in Texas as traffic court, because it's not traffic court.
Okay.
It's criminal court. It's just usually a court of no record. And most of the cases they handle deal with traffic, yes. But the fact is that these same courts deal with any Class C offense.
Okay.
Doesn't have to be traffic. It can be any Class C offense.
Okay. So in a criminal court of no record, someone who's being charged with a traffic crime, is it simply, or let me ask this, how far would it get them to object and say, I was not engaged in transportation?
In that court, it wouldn't get them anywhere. But here's the thing. These courts, being courts of no record, are all about the appeal. They're not about the trial. They're about the appeal. Anytime you are charged with a crime and you are tried before a body that is acting non-judicially, and when I say non-judicially in this instance, it's not a true judicial body until it's a court of record. Okay? Since 99% of these municipalities and all JP courts in Texas are courts of no record, okay? There is no court reporter. There is no official stenographer. There's no one there making an official record of the proceedings in that court. Hence, they're called courts of no record.
Nobody ever knows what happened.
Exactly. Now, if you're smart, you're recording the entire thing yourself. You're not telling them you're recording it. You're not showing them recording it. You don't even let them know you're recording it, but you had better record it. But this is the reason why in any of these courts, whether it's a court of record in the larger municipalities, most of them have courts of record. They have an actual court reporter, et cetera, in the larger municipal courts. The fact of the matter is they tamper with that record. I know. I've been to these courts. I've had records from these courts, and I know for a fact they tampered with them because I recorded the proceedings and then compared them to the record. They tamper with the record. That's why it's so imperative that you record the thing yourself. But the basis of what you do in these courts is to do everything in writing. That creates a paper record, even if there's not an official transcription record of what was asked and argued and testified to. There is still a paper record of what you went in there saying from the very beginning. And so we file specific things in these cases, the first one being an affidavit of not engaged in transportation. I, as an individual, was never engaged in transportation of any kind upon the highways of the state of Texas. I was not hauling any passengers, properties, goods, or services for compensation or hire, which is what transportation is. It's using the roads for commercial purposes. And by commercial purposes, we are limited to actually using the road as the place of business, like a truck driver does, like a taxi driver does. Those are the people that are engaged in transportation, not you and I going to and from the grocery store, going to and from work, going to and from school. We're not engaging in commercial activity. We're engaging in the rightful activity of locomotion, the freedom of movement. And the courts have always distinguished between those two things. Now, when you listen to the arguments from the other side, especially the attorneys and their paralegals, they always want to go back to the driving is a privilege. They're right, as long as the context of driving is transportation. Okay?
Right.
When they get out of that context, then the water is not so clear. And that's the part where the courts themselves hide behind the terminology to create that smoke and mirrors appearance of one thing is the same as the other, and they're absolutely not the same at all.
So, So it sounds like it's still a difficult process. It's not easy for, I've experimented with this several times in California and in Texas.
Well, the difference there in California is in California, these are civil infractions, and
Right.
you have no judicial process in which to challenge this. Everything they do in California is administrative. It's civil administrative. They can declare you liable for it, and there's nothing you can do about
Right.
it except appeal
Well,
it.
it's in a way it's kind of the same because you do have an appeals process that you can go to, and I believe that goes to an actual appellate court, which is I'm not sure if it's civil or criminal, but it's an actual court. It's of record, and they do. I took an appeal one time there, and it was all in writing. We never had to appear, but it was. They actually, they said there was a miscarriage of justice in the lower court, and they actually did follow the law and did correct it. So I think different, but somewhat similar. But yeah, that said, I did do a lot of experimentation, and in the end, what I ended up doing was I got wind of, okay, jurisdiction. What does jurisdiction mean? And then I thought, if I have a driver's license from another state, or what about from another country, they don't have jurisdiction to suspend it. So they're not able to basically blackmail me anymore, right? Because that's what they do. If you say, I'm not going to pay this ticket, they say, oh, well, if you don't pay it, we're going to suspend your license, and now you're driving with a suspended license, and the penalty goes up.
That depends upon whether or not they have a reciprocity agreement with
Right.
the state or country of origin for that license. Now, what they can do is they can suspend the use of that license within that state, but they can't
Interesting.
make it null and void where it was issued unless they have a reciprocity agreement. But see, right there is proof positive that you're dealing with a commercial nature. Why? Because the United States Constitution absolutely forbids any state to enter into any form of compact or agreement with any other state without express approval of Congress. Well, Congress can't approve something that falls outside of its 18 enumerated powers. Okay? Congress has no authority to intercede in anything that is not covered by one of those 18 enumerated powers. So what is the only power given to Congress that allows them to reach within the day-to-day activities of any given state? That is a question.
I'm thinking. I'm thinking money, commerce.
The Commerce Clause. The Commerce Clause is the only clause in the entire federal Constitution that authorizes the United States Congress to act on something occurring within the territorial borders of the states themselves. Okay? If that activity falls outside any of the other enumerated powers. If it has to deal with commerce, and Congress, by the way, has abused that one considerably to get a hold of the states in ways they were never meant to, but they've done it. And it goes to a lot of what we're talking about here. The Commerce Clause is where they get it. So if the Congress is using the Commerce Clause to approve a compact, which is an agreement between one state and another, then the subject matter of that compact or agreement must relate to the authority granted under the Commerce Clause. It can't work any other way. It doesn't have anything to do with the counterfeiting clause, does it? Where
Right.
Congress is given the sole power to coin and mint money, right? Doesn't have anything to do with treason, which Congress has the power to prosecute.
Right. Okay.
Okay. So what power are we talking about? There's only one it can relate to, and that is the Commerce Clause. So that compact between the states must relate to something commercial. It can't relate to something non-commercial because that's not within the purview of Congress to approve or deny.
So I'm trying to think of examples outside of that, and I've heard that. I don't know how true this is, but I've heard that they've tried to use the Commerce Clause to extend into regulating cannabis, and there's also the sale of alcohol. I don't know how. So
because they always use the argument about it crossing state lines. And because it crosses state lines in commerce, they have authority over it. That's not what the Commerce Clause was set up to do. That's not what it was ever intended to do. When it says to make commerce between the states regular, that has a very limited meaning and purpose. The regulation of commerce between the states is not to tax it or control it or dictate what it is or isn't. It is to ensure that the states don't violate the other part of that clause within the federal Constitution, where they can violate the compacts between states, or they can create monopolies on certain products because they're the only state that produces it.
I
The
see.
regular part means if you have a commodity that you produce only in this state or these few states, you can't price gouge the other states to have access to it. The
I see.
exchange of goods and services between the states is to be regulated so as to be uniform and fair and impartial between all of the states. That's
So that
what
might
they were
be
intended to do.
that might be if like I think Colorado sells water to some surrounding states. So that would be so that basically Colorado's not price gouging or something of that nature. Is that
Exactly.
okay? So when you
They're
say
not charging New Mexico more for the water because they're in bigger, desperate need for a water supply
Right.
than Texas is.
okay, so when you say Congress has abused this power, has this been challenged in court? Have the courts agreed with it and upheld it, or what's like? How are they able to keep this standing and keep this enforced?
Well, the answer to your question is both yes and no. Yes, the courts have addressed it. Yes, the courts have said it is unconstitutional. And yet, the courts ignore it and don't enforce their own rulings on the subject. And then they create new rulings that do exactly the same thing with those subjects as they do with the subject we started out with, transportation. They make it appear as if what's happening is valid, but it's only valid within a specific given context, which they are not divulging.
Right.
The way it works is federal funding. The federal government controls the states through the purse strings. The states get federal funding to do certain things as long as they're willing to implement federal law relating to how those funds gets used. The state must enact programs that the federal mandate attached to those funds requires. The state must manage those funds according to those mandates, and they must comply with the federal mandates in every way in order to maintain that flow of funds into the state. Well, Title 49 of the United States Code, the Federal Motor Carrier Safety Act, is exactly where licensing, registration, financial responsibility, and all of the other commercial enforcement laws within the states come from. On my legal blog, taooflaw.wordpress.com, I've actually got copies of two different records, transcribed records of our president, which I believe at the time was, I think it was Truman. I forget which, but if you read it, it's there. And in both instances, he is publicly speaking about the federal plan to implement requirements for driver's licenses and how they were going to get the states to enforce the federal mandates by paying them to institute the programs within the states. This was 1922. By 1925, licenses were in place for commercial drivers. It wasn't until the 1950s, however, that they started making everybody believe they had to have one.
Interesting. And this is, I had someone tell me a similar story about the income tax, that it was up until World War II that only federal money or federal corporations were taxing their employees because that's all it covered. But then in World War II, the government was, everything turned into war, everything. Everybody was manufacturing for the war. So all this federal money was coming in, and that's how that converted everybody to start filing and paying income taxes because now they were receiving federal income. So was there some sort of event that you know of that helped that transition with the driver's license between, like, how did they just come out one day and say, oh, everybody's going to need a driver's license if you have your own car? They
did it over slow encroachment like they always do. They started convincing people that there was a benefit attached to acquiring this little conversion kit. The conversion kit being, we're going to take your right to do something and we're going to convert it into a privilege to do something by calling it a licensable activity. So we're going to start issuing these licenses. And with this license, you get these benefits. And if you want these benefits, then you have to get the license. Well, the benefit of the license was to provide remedy. Okay, now let me explain what that means. The licensing laws and most of the other regulatory laws are actually what is called remedial law. They're there to provide remedy for harm. What the statutes were originally written to do was to provide a means to establish specific facts and circumstances that when someone engaging in the activity regulated by those codes and those statutes harmed someone else through their actions, then those statutes could be used to establish specific checklists to say, were they doing this? Were they doing this? Were they doing this? If this is all yes, or the majority of this is yes, or the important parts of it are yes, then the person injured can use these established facts to sue that person to get remedy and to be made whole for the injury they received because of the actions of the first party over here. That's remedial law.
So basically,
that's what they were intended to do.
So basically, me sitting here without a license, oh, the government's offering licenses, I should get one because if I'm ever in an accident, it makes me look innocent. Is that
it covers me in certain ways,
right?
Yes.
So that's really interesting because, like, I'm thinking of, like, you know, when you go to a grocery store, they usually have a thing where, like, you know, you sign up, you give them your information, and they give you a little card that you carry around, and every time you buy something, you swipe the card. Once in a while, you get a discount. And to most people, that seems almost kind of like the same thing because you're like, yeah, I'll give them a little bit of information. Nothing bad will ever come of this. And of course, that's a grocery store. When people started getting their licenses, obviously transportation was new. They didn't have probably speed limits and traffic citations and all these other things that were going on. So it probably didn't seem like the risk was that big to get that license. So it's like, okay, I get the license, I receive benefits, and there's absolutely no risk. Do you think that's fair to say?
It's a way that it could have worked, but there's actually, in this particular instance, there's a more blunt hammer approach. What actually happened to compel more people to acquire the license was the courts started changing the facts to suit the outcome they wanted, instead of the one that they were supposed to be delivering. What the court started doing was obfuscating the terminology, just like what we've been discussing. They use the term drive. They say drive's a privilege, and the privilege requires that you acquire the license. They don't attempt to keep the two things separate. They make it look as if it's all one thing, when in fact it is not, and it never has been. It can't be. It's exactly the same thing they try to do when they argue that you would laugh in the face of somebody who said the Second Amendment is limited to muskets.
Right.
Okay? But this is exactly the argument that every one of these courts attempts to use when they say you have to have a license to get behind the wheel of a car. Because it's got a motor, it's dangerous, and because it's dangerous, it's a privilege in order for you to have it and use it. But here's the thing. You don't need the license to buy the car, do you?
Nope.
You don't need anybody's permission to buy the car, do you?
Nope.
Okay. So what privilege are you actually exercising when you buy the car? Zero. Goose egg. No privilege whatsoever. You have a right to buy that piece of property for yourself and use it for its intended purpose. You always have.
Well, I guess they don't have a license requirement on it, but they are trying to regulate it now so that as soon as you buy it, the deal, as soon as you buy a new one anyway, the dealer has to register it for you and
bingo, and
make sure it's in their system.
There's the thing. This is where they have misconstrued the statutes on what's called first sale. Okay? And again, what is the one thing the statute within the code cannot legitimately do? It cannot act outside of the context of the code in which it's contained.
Right.
Right?
Right.
So first sale does not apply to someone who just buys a car to use at home. First sale applies to someone who buys a car to use for transportation.
Right.
Can't be for any other reason. Because if you're saying transportation means private use, then you have to show where you're getting that definition and use from. And there is no case law anywhere. There is no legal definition anywhere that puts transportation in a private activity. It's always relative to commercial use of some kind.
So I want to ask, in practical terms, what can someone do with this information? Is there a way that you can go to a dealership, or do you know anybody who's been able to say, I'm not going to be using this for commerce, you don't need to register it? Or are all the dealers just so brainwashed that...
You can do it, but you don't do it that way. Okay. What you do is you go down, and here's the problem. You cannot buy the car with a loan. The car has to be bought. The banks want it registered. Outright. The banks want it registered because it's how they use the state to secure their loan.
Right.
Okay? When that agreement between you and the other party for that loan is established, that loan is registered to the state as a lien against that property. You have rightful possession and use, but you don't own it. The bank does.
Right.
So the registration becomes a certificate of title, which is the record of that outstanding lien claim the bank has against that same piece of property. That's all that certificate of title is. It's a notice of lien. And it's what gives the bank a claim to that property. Without it, it would be your word against the banks as to who paid for it, right?
Right. Yep.
Okay, so that's what that piece of paper does. When you do that, the state then registers that car, but the state does something illegal at this point. The state makes a presumption about its use that it's not allowed to make unless there's paperwork filed by you that says the presumption is valid. This is where the dealership screws you up. The dealership has you fill out all kinds of paperwork, and you don't know what 99% of it is.
Right.
So not only are you filling out the paperwork for a certificate of title, you're filling out the paperwork for first sale, which says you're using it for commercial purposes.
Just by having that word on there that says first sale.
Yeah. Once the car becomes the object of a first sale, the presumption of commerce is now valid.
Right. Wow. So let's talk about, let's go back to the driver's license. Is it possible for somebody to drive without a license, or like what kind of trouble are they going to get into with the police?
Give me the context and definition of the term drive.
So, well, okay, traveling, not driving.
Nope. Now, see, here's the other thing where people make the biggest mistake. This has nothing to do with traveling as the courts have defined the term traveling. Okay?
Okay.
Traveling in the way the courts have ruled is movement outside of the U.S. to foreign countries and back into the U.S.
Okay.
That's travel. The courts have repeatedly said that movement between the states is locomotion, i.e. the freedom of movement. from place to place. Locomotion is the term we're looking at here, not travel.
Okay.
So where the courts have ruled that there is a distinction between locomotion and transportation, one is a matter of privilege and the other is a matter of right. Locomotion is a matter of right. And this is where we get to the issue of reinterpreting the Second Amendment to mean only muskets, or the First Amendment to mean only quill pens. Okay? Typewriters aren't protected under the First Amendment because they're new technology. Just like the modern firearm or the modern gun is not covered because it's not a black powder musket. And automatic weapons aren't covered because the founding fathers didn't know anything about a gun that could shoot multiple times with a single trigger pull, when in fact they actually did. There was a gun invented almost 200 years before the Constitution was established that was fully automatic cannon. And the founding fathers knew very well about it. They actually used one against the British.
Nice.
Okay? So all of that cockamamie BS about the car being something new that the founding fathers couldn't foresee is asinine. It's a ludicrous argument. You are basing the ability to exercise a right upon the existence of technology relative to that right. And that's not the way a right works. If I have the right to acquire a piece of property, I have the right to the use of that property for its intended purpose. And the courts have said exactly that numerous times. You cannot say someone has the right to acquire something and then turn around in the same breath and say, but you can never use that thing you bought.
Interesting.
Why? Because I didn't give you permission to use it. And if you don't get my permission first, then you cannot use it. That's not the way it works. That's one of those delegated powers we did not give to our representatives or to anyone working as our representative or for our representative. We can't give that power. I can't take your power away as my neighbor to paint your house whatever color you want, to put whatever you want on it, in it, whatever. I have no power to do that. So how can I give it away to my representative?
So going back to practical terms, because we've talked about how courts are able to, court of no record is able to just do whatever they want. What happens when you get stopped by the police and you don't have a license and you want to somehow, like, is there, and I've seen some YouTube videos that are kind of questionable where somebody kind of gets away with it, but what's the actual likelihood of a person not having a license and surviving a traffic stop?
Okay, I've actually, years ago, at the same time I did that video, and I actually talked about that on InfoWars as well, was the transportation practice script. The transportation practice script is intended to do one thing and one thing only. And that one thing has 3 steps. Invoke your rights, demand your rights, protect your rights. Anything you say and do at a traffic stop that is not doing one of these three things is something you shouldn't be saying or doing at all, period. Okay? That's why the primary rule of any police encounter is first you shut up. The second part is after you've done step 1, shut up some more. And finally, in step 3, when you're sure that you have perfected step 1 and step 2, keep shutting the hell up. Okay? Do not engage the cop in conversation. Do not attempt to explain yourself. Do not ask questions that border on conversation. It's that simple. Shut up. The transportation script has you asking specific questions and making specific statements that do only one of those 3 things. It either invokes a right, demands a right, or protects a right. When a cop asks you a question like, I need your license, registration, and proof of financial responsibility, the first thing out of your mouth, officer, I'm not an attorney. Therefore, I need to know, can any of the information you're demanding from me potentially be used against me in a court of law or to incriminate me in any way for any other type of charge? The answer to that, of course, is absolutely yes. Absolutely. Since we have those rights to remain silent, which includes the right not to produce anything that can be used against us, whether it be documentation or anything else, how then can we be compelled to comply with a directive to give them something they can punish us with? We can't. It's straight up plain and simple fact. This is what I was saying about how they intentionally violate their own rules. How can a court legitimately say you have the right to remain silent, and that right includes the right not to produce anything, well, any kind of evidence, any kind of statement, any kind of answer to a question, any kind of paperwork that could incriminate you in some other crime or be used against you in a court of law for this crime, and then in the next instance turn around and say, but you got to give it to them anyway. That's not a legitimate way to preserve a right, is it?
No.
Okay. So again, when the court says you got to do this, the court is talking about someone who's agreed to do it in advance. And the only one who's agreed to do it in advance is the person who voluntarily engaged in transportation to begin with. That's why that element of transportation must exist, because the cop's jurisdiction to perform that traffic stop is under what code?
The transportation code.
Bingo. Therefore, he is attempting to invoke the jurisdiction associated with the transportation code. That's not a general jurisdiction, okay? It is a specific statutory jurisdiction. And in order for anything that is applicable under that subject matter to give him the means to make that stop, that subject matter must apply. So how is he invoking it? Officer, can you please give me the articulable facts in your possession of how you came to the conclusion that I was engaging in transportation? Do you know, in one of my cases, I literally had a prosecuting attorney stand up in court. I object. No one is attempting to charge Mr. Craig with engaging in transportation. Bingo. Thank you very much. Judge, there you have it. The prosecution has just admitted the subject matter was never invoked in this case. Does not exist.
Perfect.
You know, that was that. Next thing I know, case dismissed.
Man. All right. Well, I don't want to hold you up too much longer. We've been talking for over an hour now. I want to give you an opportunity to talk about any projects you're working on, and obviously to promote your websites, which we have on the screen under your picture here. So just go for it. Anything you want to talk about?
Well, I have a seminar material that I wrote way back when, before I even appeared on InfoWars, dealing with how to fight traffic cases and stuff like that in the state of Texas. It's got a book, explains what all the statutes are, how they all work, the logic behind them, plus the logic of how they're trying to use them and how that use conflicts with the actual law. Right now, my biggest project is getting an update to that. I'm writing an entirely new book that incorporates all the new changes to the statutes. I'm writing all new legal documents for filing in the court cases for the new book and the new way of fighting this. Of course, we're always trying to keep the radio show going as well. And hopefully I'm going to have a new full-time job here running a huge aquaponics farm that I'm going to be responsible for building and setting up. And that's pretty much what I'm working on. I very rarely sleep. I get like 2 hours of sleep a night if I get that. And of course, I have a very good cow dog down here he's the one nuzzling me wanting to go out for a walk. But so your timing's good. He's very impatient when it's time to go.
Perfect. Awesome. Well, thank you so much. This has been an awesome talk. Learned a lot. Hopefully all my viewers did too. Go check out Eddie. Go visit his website. And actually, let me ask you this. Social media pages. Do you have any social media pages anyone can follow?
Yes, I am on Facebook under several. There is Tao of Law, TAOOFLAW, which is one of my landing pages on Facebook. And then my personal page is Tao Law, and that's TAO space LAUW. And I also have a legal discussion group called Tao of Law, TAOOFLAW, on there as well. And that's where I try to do what little bit of teaching and assistance I can provide right now. I do through that discussion group and in private chats on Facebook for the most part. And then if we need to get off of Facebook for sensitivity reasons or subject matter reasons, we'll move it over to Skype or email or something like that.
Right. Okay, perfect. Well, thank you again. This has been very, very informative. Hopefully everybody learned some great stuff. And make sure to follow Eddie on Facebook and check out his websites and his radio show. And we'll see you next time. Taxation is theft. Taxation is theft.
Please, at least leave us alone in our living room.
My job is to find the truth.
Double the taxes. I'm a human being. God damn it! My life has value. Triple the taxes.
This is an IRS agent's dream.
If you think that the Capitol will ever treat us fairly, you are lying to yourself.
Beautiful, lovely taxes.
Sorry, but I don't do taxes.
Did you see the memo about this?
The government is a greedy piglet.
Just leave us alone.
Do you know what Ralph just said?
The roads.
You boys like Mexico?